this long. I know it's been, panel after panel, so I appreciate that you guys are still here. I have the honors of introducing our next panel, and I will just let folks speak for themselves so they can touch base on who they are and answer questions if they haven't yet about what they would like to see evolve or change. So I can just say really quickly that I just feel really inspired by listening to everyone today, especially folks in this role, because it seems like there's been a lot of evolution in terms of people and systems understanding, or just listening to what victims and survivors are saying and needing, and how folks within that system have been trying to circumvent further harm from occurring. So that's something I just feel really inspired by, and I appreciate you guys talking about. But yeah, I will start on this side, if that's okay. I'm like, no pressure, yeah.
I guess that's me. Okay. I'm Judge Teresa Sullivan. So thrilled to be a part of this work. Briefly, as a prosecutor, I did mostly family violence, domestic violence cases where I did feel an affinity to the victims. As prior to being a DA, I represented children in dependency court. So when I was appointed, I asked to go back there and to try to do what I could to start at the beginning in a dynamic that I didn't see as an adversarial one. So I thought maybe there would be more space for the types of things we're talking about here, right? More collaboration, more input from providers, more holistic and trauma-informed process. I did my best. I did want to comment on actually something you said in the introductions, because I look at the other judges sitting next to me and the people that I've heard from in all areas, and there is, I think, an important change, right? There is an important change. I'm not someone who would have been appointed as a judge 20, 30 years ago. 40. I wouldn't have. I'm the wrong gender. I have none of the pedigree. My family gave me a flying pig statue when I got appointed because I made every mistake you could make and have much more identification with the defendant than probably any prosecutor ever should have. But as a judge, it's why I'm there. I'm not there because I went to the best school or always make the most learned written decisions. But I do try to see the human in front of me, no matter who that is, right? Whether it's the stressed out lawyer who can't do another case that day because it's too hard, or whether it's that really angry person sitting in the back of the courtroom that I know is feeling really offended by the defendant and me and everybody else in the room, right? There's, I do my best to connect. When the question of the panel was proposed, however, I think we all were pretty clear about the fact that in this role, and I think it was reflected earlier, this is your system. It's an adversarial system. And my job is to do nothing on my own. I must be moved. And that's why you're going to law school, right? To learn how to make the judge do something that you want. But I'm not, it's not appropriate for me to reach out my hand to one side or another, or someone who doesn't feel represented by anyone necessarily. If the legislature decides to tell me that that individual has a right to standing and a right to an attorney, and that I am bound to do that, then I'll certainly do that. But in the way it's set up now, most oftentimes, any special attention that I give to a victim can be perceived as favoritism to the prosecution or prejudice against the defendant. And I think it was just expressed earlier, you know, I'm a mom too, right? And working in children's court for so long, I really want the particularly the younger witnesses to feel really comfortable. And when I first was appointed, I would make it a thing, you know, I'd bring the lawyers together and I'd say, look, I really want the young witness to be able to come into the courtroom before and look at the, and then I can't do that stuff. I can't do that stuff. That's not my job. I can't do that stuff. So what I have come to terms with is the only thing I can do is try to do that connection, right? That I do see you, but I can't, I don't feel that it's within the bounds of my position to take any action on that directly. And I know that that's perceived, you know, that people come into the court and say, why didn't the judge help me out? Or why didn't the judge acknowledge my position? I'm not an advocate for one side or the other. I'm not. You know, I do try, as I said, to make people feel comfortable. I do try to make a human connection with everyone, and I believe in my deepest heart that access to justice, because that word matters to me. And I know it doesn't happen all the time, but that is my goal. That people say, well, it didn't come out the way I wanted, but it was fair. Or I didn't like what that prosecutor did or whatever, but at the end it was fair. So if I can create a dynamic where that is most likely to occur, that's what I'm trying to do. That's what I'm trying to do. And I just encourage everyone else to do what they're doing so that trauma-informed, that victim-aware, the legislative, I think there was Mr. Kim, and what, you know, changes in the law might be ways to get a little more access. But as it stands right now, it's an adversarial process, and she's blind, and you know, everything. She's not doing a whole lot there. Right? So I try to remember that, you know, but to bring the love in my heart.
I really appreciate you, like, just letting us, like, giving us a deeper, like, understanding of, like, the frameworks that you have to operate, you know, under, and the sort of sense of security that you're trying to offer everyone in the room. That's good to know, because yes, it is perceived differently sometimes. I'm not sure if I'm supposed to ask a question, but I want to ask it anyway. I just wanted to know, and anybody can speak to this if they want to, and if not, like, please continue along with what you have planned. But I just have been in front of judges so often where, like, I wish, like, that sense of security existed, like, if not just for me, but, like, for everyone. And I know that folks are supposed to operate without a sense of bias, but I have had experiences where like, I was, like, holding my side because I had an ulcer, and someone was like, get your hand off your hip, this is not, you know, a sidewalk or something like that. And I'm like, how is that not bias? You know? So, yeah, it was intense to have that kind of exchange with someone who's supposed to sort of exist to find justice in this situation, or give everyone equal access to, you know, their rights, the law. So I don't know. That's just something I wanted to put out there, because I think that, like, too often, sometimes you hear that sort of bias, like, peer through. And it would be great if it just existed as like a space where everyone felt like they had equal access to justice or support. So I don't know, that was just a comment, but thank you. I'm like, and you are following it.
All right, great observation. Maybe I can comment on that too. I'll introduce myself. I'm Judge Curtis Kinn. I've been with the Los Angeles County Superior Court for 8 years now. And prior to that, I was a prosecutor, but for the federal government with the U.S. Attorney's Office. Among the various types of cases I handled, I did human trafficking cases and was in charge of the unit. And I would say probably some of the most meaningful work that I did was the human trafficking prosecutions work that I did, and it was most meaningful to work with and vindicate, in my view, the rights of victims. So that was very fulfilling. So I brought some of that to the bench, but to echo a lot, I think, about what Judge Sullivan was talking about, I can't bring too much of that to the bench, or at least I'm limited in my role, even if I am bringing that empathy with me to the bench. Kind of hearkening back to like a couple of weeks ago when the best judges on the panel met with Professor Richards to talk about the question, which is what do you believe could be changed or improved in the criminal justice system? And I think we all stared at each other for like a couple seconds or longer on Zoom, because all of us realized we don't really have a role in that I know that's disappointing to hear, but it's hard for us because we're not advocates, we don't develop policy. We have subscribed to the notion that this system is the best system because it's an adversarial system, and the adversaries have to do what they want. And we have great power. I'm not ignoring that fact. But our power also is greatly limited. You don't ask, you don't get. And I don't do as a judge unless it's asked of me. So that's where my decisions come from, is it's because it's asked for. And so ultimately, I think what our goal is I think as judges, we're process-oriented. So I feel like I have met my goal if I have overseen a fair proceeding. I am not driven by any particular outcome, and in fact, in my courtroom, I have to balance all the competing interests that are before me: the rights of the victim, the rights of the people/prosecution, the rights of the defendant. And so what may be good and what may be desirable and what Curtis Kinn may feel is good for a victim may not be what I can give in the courtroom, because those interests may be very much adverse to the defense, maybe even to the people, even if the victim is a witness for the people. So it is difficult, I think, for any of us judges to recommend any changes or improvements to the criminal justice system to favor victims, even though I think we all recognize that's a very admirable goal, and I wouldn't want to stand in the way of it. But I also can't quite facilitate it because of my limited role in the courtroom. And I know it's sort of contrary, right, to what you might think. You think, okay, here's the court system, the judges are part of the court system, the judges even call themselves the court. Why don't they have the right, and why don't they make those decisions? Why don't they make the changes? But it's just not our role. We have to balance the competing interests. So I guess maybe one of the takeaways, at least, that we can give you all here, both the victims and victims' right advocates, is just to understand that the court's job, the judge's role, is quite limited. Maybe that helps a little bit with the frustration you might feel when you walk into court and you want something to happen. Why can't Judge Kinn do this? Why can't Judge Sullivan do this? And it's because we have to be fair to everyone before us. Even if personally we may not agree with what's going on, we have to be fair before everyone before us. And as Judge Sullivan said, we're unlikely to ever act on our own, even on good ideas. If you don't ask, you don't get. And so your job, I think it's the phrase you used, Judge Sullivan, is, you need to move us to act. And I think that's right. So as advocates for victims, or if you have victims' rights advocates advocating for something, you ask, you advocate hard, and then the judge will act. And that's how you can institute change. That's how you can get what you want in that courtroom. Okay, with all of that prefaced, let me turn to actually trying to answer the question. Because I think I can in somewhat answer this question in terms of I can focus on what happens in the courtroom. I'm not going to talk about the criminal justice system writ large, certainly not my job beyond what I can do. And because I think there are things that the court and the judge can possibly do in his or her own courtroom, perhaps to make a victim feel more comfortable, perhaps to avoid the re-traumatization of a victim in the courtroom. And I think this dovetails on your comment. It's because I would do the same thing for any witness, right? Any witness before me shouldn't have to be traumatized as a result of testifying, no matter which side the victim is testifying. And I think every witness, victim, prosecution, defense, should feel comfortable in the ability to testify before the court. I think that's my job, and frankly, our job is to further the truth-seeking function of the court. And so if witnesses before me, victim, defense, prosecution, or otherwise, are comfortable in testifying, not being traumatized, I think that furthers that goal. And in that regard, I feel like then there are certain accommodations I feel I can make to a victim witness when I look at my role in preserving the system, because I would do that for any particular witness. This is from the smallest, like allowing victim witnesses to come in and check out the courtroom before they ever have to testify so they know what it feels like, allowing them to use the attorney or witness room to set up camp or bring support people. When they're testifying, allow them, in certain circumstances, to bring comfort items. I know some of you have these squishy balls or like stuffed animals, or even, you look at the law in California even allows for support people in certain circumstances. You can have an advocate or a support person there. And I think as a judge, I can allow that. I think the law provides for that, and I will provide for that for other witnesses as well. In fact, I think with great success. I've done this in my cases as a judge, because as a prosecutor, when I was having victims testify in human trafficking cases, I would take them to court, and I would show them the court, and I would let them sit in the witness stand. And I was very grateful that the court allowed me, meaning the judge or the clerk allowed me to do that. And so now as a judge, I do the same thing. And I'm not talking just victim witnesses too, again, since I have to be fair to everybody, in the same way that I allow defense attorneys or plaintiff's attorneys to come in and use the projector or see if the technology is working, or bring people through the courtroom so that they're comfortable, so that the whole trial goes more smoothly and that the truth-seeking function of the court can go more smoothly. I allow that for everybody. And that's why I feel I can allow that for victim witnesses as well. So I think that's what I have. I guess I just was sort of, one thing I kind of been positing that I sort of think about is whether or not, in furtherance of victims, witnesses in particular, feeling a little bit more comfortable or not being re-traumatized, I sort of go back and forth on whether it would be like remote testimony in hearings would make some sense. I mean, I'm very aware that the law is such as that at this point, because of the rights of defendants in the Confrontation Clause, but for testifying minors, showing good cause of trauma, harm, or otherwise, that's not allowed. And again, that makes sense to me, balancing the interests of the defendant's Confrontation Clause rights against the rights of witnesses to feel comfortable and not be traumatized and the like. I wonder with technology if that changes. We're now part of the Zoom generation where we've had pandemics where, you can look eye to eye at a hearing and through, the screen. And I wonder if that would be sufficient, or if the courts eventually will find that to be a sufficient protection of a defendant's Confrontation Clause rights and all of that. I think that might be a balance that the courts could strike. I'm not positing one way or the other, but I think it's an interesting thing that might be coming up as the courts are getting more and more used to technology. We're all getting more used to Zoom, and I think you can preserve the right to actually confront and cross-examine a witness through Zoom. So, but that's what I have.
Thank you.
I'm the last speaker of the last panel. I don't know what I did to deserve that. So I appreciate you all still being here. My name's Wendy Siegel. I've been a judge for 3 years. I'm in a criminal court at the Fultz Criminal Justice Center downtown. I'm in a misdemeanor arraignment court, mostly with domestic violence defendants, because that's who are now mostly in custody based on the new zero bail and because of COVID. I want to first say to, and I don't even want to call you victims, but the survivors that spoke today, for your resilience and for sharing your stories with us. I know how hard that is. And I listened to what you had to say about being in the courtroom and how you're treated. And is Jimmy still here?
Yeah, I'm still here.
Okay. And to be believed. And I just, as a judge, I know court is scary for everyone. Everyone. The new public defenders I have in my court who come forward shaking, it's scary for them. It's scary for the new prosecutor. It's scary for the defendant, whether the defendant's in custody or not. It's scary for the victims to just even be sitting there to find the courtroom they're supposed to be at. They've given the runaround of where their courtroom is. Nobody knows. No one's being nice to them. It's a scary place. And I try and be cognizant of how scary it is. The defendants that come to my court are in custody. I have to make a determination whether they stay in custody or to release them. And there's not much information I have. I read the police report. I really try to find out what's going on with this particular defendant. I look at his rap sheet. Is there a drug problem? Is there an alcohol problem? What happened here? Are they homeless? Is there a mental health issue? And I really try and treat everybody with respect and dignity in my courtroom, no matter who it is. When I'm done with the defendant's case, I always say, good luck to you, sir. There's another issue in making my determination whether someone's going to be released on bail or they're going to be released to OR, they're going to stay in custody, what we're going to do. And I want to address your issue with domestic violence and why defendants are let out and then keep victimizing you. Many times, the victim of domestic violence comes to court that day. They called the police the night before and had the defendant arrested, but they come to court the next day and say, I'm not scared of him. This is the only time it happened, or it's happened before, but he promised me he's not going to do it again. And they don't want to testify, and they say, I didn't want to press charges, which it's not really there. I think mostly everyone knows it's not up to the victim. So there's a problem a lot in domestic violence cases, and even when people know the defendant's committed domestic violence with a prior relationship, they still have a relationship. I see that over and over. So I have a quick decision to make whether I'm going to release the defendant or not release the defendant. If I'm going to release them on an ankle monitor, they're always issued a protective orders. Protective orders sometimes work, sometimes don't work, as I'm sure you know. But I really try to listen to everyone when the defendant's parents are there. And in my mind, they're sort of victims. They don't ask for this. Sometimes there's a mental health issue that I see the parents, with the pain that causes them, that they can't help their child who has this mental health issue. And I thank the parents for being there. I actually never really speak to victims in cases. I mostly speak to a defendant's family and thank them for being there and sort of say to the defendant how lucky he or she is to have their parents there or family members. And where's Jimmy? In believing defendants, sometimes I'll look at a defendant's rap sheet. It says he has 17 bench warrants, and so I'm not going to let him out because I don't think he's going to come back to court. And just last week I had a defendant say, no, I cleared those up. I was in department this, and you know what? I knew he was telling the truth. I could tell by what he was saying. So we ran him, and sure enough, he had cleared up all his warrants. I really do listen. As the public defenders, I know don't want their defendants to say anything, but sometimes I'll let them they want to speak. They're locked up. It's a degrading process to be locked up there and no one's listening to you. So they'll speak. I'm not going to infer guilt based on what they're saying, but sometimes they have something they want me to hear. And just like everyone in that courtroom, they want their moment to be heard. And I think that the bench is changing and judges are giving everyone an opportunity to be heard. And that's something that I try and do. I was a career prosecutor for 25 years. Oh, gosh. And I did stalking cases for 8 years. And 99% of those defendants had mental health issues. They were schizophrenic, they were bipolar, they were untreated and undiagnosed. And that's what I'm seeing mostly now and almost in a lot of crime. And so I try and look and see, I treat that victim, that defendant as a victim of mental health. It is not their fault that they have that issue. So I think we need to look at those cases. Really quickly, in answering the question, we were asked the same question you were all asked, and as I said, we can identify the problems, we can't provide a solution, which is what they wanted. I think that victims, for the most part, want to be informed, they want to be provided for opportunities for input, and they want that input to be carefully studied. They don't want to come to court over and over and over again, being re-victimized. Cases get continued and it's no one's fault. A new lawyer's on the case, they're not ready, the case gets continued, the witnesses are in court, you have to tell them to come back. And there's nothing worse as a prosecutor than having to do that. Now as a judge, I can't fix or provide solutions other than that prosecutors really need to keep in touch with their victims. Victims want and need their voices to be heard at every stage of the process. I think that changes need to be made to ensure that restitution is ordered, monitored, paid, and received. You know, sometimes people say, oh, it's just a stolen car. Well, to that victim who doesn't have a lot of money, that's their mode of transportation. It's not just another stolen car. So we need to recognize that they need to be whole again. And I just think victims need to be given their opportunity to be heard just like anyone else in every case.
Mrs. Wendy, thank you. I wish you were in my detention center courtroom.
I wish I was. Thank you.
I really appreciate also, I mean, you spoke to like that domestic violence situation, and I think I've been that person. And I just think that like speaks to your lack of understanding of healthy relationships and like the
My
fear.
lack of
No, not yours, I'm
Oh.
sorry. Victims. Excuse me. Lack of understanding of healthy relationships. So sorry. And like, yeah, this like the trauma bond that exists and the fear and kind of coercion that's behind all those things.
It's heartbreaking when the victims say to me, but he loves me and I love him and we're having a baby. It's hard.
Yeah.
It's really hard.
But what's really great to hear is that there's like this depth of understanding behind all of this, because you're not allowed to show it. That there's a lot of thought, and just to hear it, right? We might know it, but just to hear it be said is really comforting. But it also puts like a lot of pressure on like the defense and the prosecutor to be strategic, right? Because you need to hear those things. Awesome. I think that we have two folks here who have some questions from the audience. Or oops, did you guys want to? Great.
You guys see the mic is taller than me. I'm 4'11". So. Good evening, everyone. My name is Catherine Clark Perkins. I am a lead LA chapter core leader. Crime Survivors for Safety and Justice gave me this opportunity with Rise Clinic, and truly it is an honor to be here before you. I feel privileged. I'm with the judges, right? But without further ado, I'm up here to ask a question. And you spoke about how do you balance, being a judge. And like you say, you have that role, the power, even Wendy, how do you guys look at it from a trauma-informed lens, even from a harm reduction lens? And even when you talked about the victim, when the victim come to court and she's telling you, oh, I love him, oh, this only happened this one time. But do the judges also take a domestic violence victims training to see the impact of the brain, more into it? So I don't want to keep going on. I gave you guys two questions. I'm sorry, but
Well,
I can answer brief. I'll answer
I'll do
briefly.
what you go ahead.
Independency, I got a lot of training. It was really great. I got a lot of good training. Trauma informed. Some of it was intuitive or I knew, and some of it was very counterintuitive. I thought that maybe, sit down was gonna, anyway, there was maybe asserting authority is not the thing to do, that would be a re-triggering, victimizing experience. My takeaway has been that the thing I can do is access, and access is information. And one of the issues that I think the family, the victims, have is the jargon and not understanding what's happening. So even if it's a continuance, and it doesn't really matter what the parties are. If I have people in the audience that are interested in the case, I do reiterate in English what's happening. Well, the attorney for the defendant needs more time to investigate. The defendant has a right to have a ready, informed, and prepared lawyer. So we are going to take more time to allow that attorney to be prepared. Something like that, right? So that people don't feel in the dark about why are we continuing, what's going on here. They might not like the answer, but I try to provide the information.
Thank you.
I'd also like to say, in terms of just ongoing judicial education and training for judges, I'm proud to say I think California is among the best, if not the best, in the nation in terms of offering ongoing education for its judicial officers. And LA County in particular has its own robust judicial education, such that other bench officers from around the state will take advantage of our programs. I myself have even taught classes to other judges around the state on human trafficking and trauma victim-centered approach. In fact, I taught one several years ago with Professor Richards. We were on panels together. So I'm proud of the fact that California has that we encourage, if not require, our judges to take part in that as well. So I think that helps.
Yeah.
On the other hand, judges can't avoid it, and if they don't want to do the education, there are ways to avoid it, which is unfortunate. But I think we'll just call it the newer generation of judges, and by that I mean the last several. We're all doing the education, so maybe over time this is something that fixes itself. Yeah, but I think it's important. Yeah.
Thank you. Let's give them a hand.
Well, I think I'm the last one to ask questions. I supposedly ask questions, difficult questions, but it turns out, no, that I can tell you are knowledgeable judges because you answer most of the questions that I had in mind. So there's no more questions. I just want to acknowledge the fact that I can understand from what you told us that you are empathetic, you understand, and also what Ms. Sullivan explained, that she cannot extend her hand right or left because of her position, and that gives me a lot of understanding coming from a survivor, because that question was in my mind, why the judge didn't understand, and she also said she's not an advocate. That was the advocate's side, and also it's like, for me, it's encouraging to hear that my job as an advocate, as a survivor, is important, because it's different when it's coming from a survivor than from a judge, because the judge is in a position to rule the law. And I'm not a lawyer, I'm not a judge, I'm a survivor. I'm telling you my experience and why these changes are important. So thank you so much for bringing that up to the table. And also, I'm sorry, your last name, sir, I didn't get it.
Oh, hi, I'm Judge Kim.
Oh, Mr. Kim, he said, like, even impacting policy, they cannot go and impact policy. And it's interesting, all of this is new to me and knowledge for me, because in my mind, oh, they are judges, they can, go and impact policy, but you told me no. So that's also another thing that makes me see the importance of advocates, of survivors coming to the table, because we come with hopes to understand and also to see these changes. And thank you so much, because I'm a person with a lot of hope And I've seen in my lifetime these changes. Before, when my case happened in 2002, there was not much knowledge about human trafficking. But now, here we are. And I always like to acknowledge that we have come a long way, that even the White House is talking about human trafficking, to find ways to eradicate human trafficking, to help survivors. And thank you to Professor Richard for hosting this event, because this is so important, and it brings, persons who can make these changes. And thank you for including survivors like me and my peers here in the room and others behind the scenes. And I just want to end up, saying this phrase that I saw on Facebook a few days ago. It says that to help someone, you don't have to be rich, intelligent, or knowledgeable. You just have to care. And you judges and all people here in this room today is what you show me, that you care. That's why you are here. Yes. Thank you so much for bringing survivors to the table, because it's a dream come true. Thank you so much.
Give everybody a hand.
Okay, now I think we have interviewers. Do I have-
So, as practicing attorneys that frequently go to court on a daily basis, we understand that we need to be impartial, and you can't help one side or the other. But as judges, I think it's important that you can be impartial. And what I've seen from some judges, in this court, in this courtroom, a smile goes a long way, empathy goes a long way, and patience. And that applies to everybody in the courtroom, whether it's the 50 people that got summoned for jury duty to the 8-year-old victim that's testifying about being sexually abused by her father, which leads me into my ultimate question of vicarious trauma. As defense attorneys and prosecutors, we, for the lack of a better way of saying it, we just get used to seeing these awful things that happen to people. Whether your client is facing 150 years of life for the crime that was committed, or the 8-year-old child who was sexually abused by their father, we're reading these reports on a daily basis, and we don't really understand how it affects us. And I'm confident it affects us in some manner. But as judges, you're hearing that as well on a daily basis. You're seeing your prelims and your trials, and you ultimately make the decision of deciding, do I send somebody to prison for 100 years to life, or do you write your sentences concurrent and give them 20 times to life? So I know you all have vicarious trauma as judges. How do you deal with that? Because the way you deal with it affects how you act in the courtroom.
Current or consecutive sentences?
Well, I'll start to answer your question. I'm doing misdemeanor, so my people are looking at not more than a year. But I do emergency protective orders every day from 8 to 12:30. Those are the domestic violence cases where the conduct has just happened. The police call me. I've done this every day for 9 months, 5 days a week, and it's all domestic violence. And I have to issue these emergency protective orders. They're good for about a week, and then the victim can go into court and try and get a longer protective order. And it's the same story every single one of them. And it's, as anybody, just as a person, it gets very disheartening listening to the same story over and over again. And then I go into court, and the people I have in custody are domestic violence defendants. So, and I'm reading police reports. It's the same report over and over. I could just say, I know the facts. And it is frustrating. And I sometimes when I answer I think today I had 14 EPOs in 4 hours. And I'm like, hello, because they call me, and I could feel my voice not being happy. And I'm like, what happened? And I have to stop myself from being angry or frustrated with the case. When I go into court, I'm not like that. It's mostly on the phone calls. I just think we have to put that emotional part aside, and we're still human, and it's hard to, when I have keep somebody in custody and they cuss me out, and I understand them cussing me out. They're in custody. They want to get out, and I let them, because I understand the human nature of it. But I really try not to be emotional in my decisions or in my disposition, if that answers your question.
So I guess I've never heard it referred to as vicarious trauma, which sounds pretty awful. But in a way, though, I think what you described, I, to some degree, have viewed as a good thing. And what I mean is this, is these are important decisions that we're making. And if I don't feel the weight of it, I think it doesn't make me a very good judge. And one of the most surprising things when I first came to the bench was how hard it was to impose a sentence. I thought, having been a prosecutor for 15 years, and I was asking for sentences all the time, and judges were largely imposing the sentences that I was asking for, I knew and felt the weight of doing that. Asking and getting is really different from the one imposing, and I did not realize that until I was doing it. And also, whether it was a murder and attempted murder cases or misdemeanor sentences, they're still really impactful on the person who's getting sentenced. So I also felt the weight of that. So to me, I guess it is traumatizing to some degree. It feels bad. I guess I take from it is the moment I stop feeling, the moment that I don't understand the importance of it and the weight of it on me, as well as, and I'm balancing interests here, the defendant's family and friends, the victim's family and friends, as well as the people of the state of California and their interest in deterrence and punishment and all of that. The point at which I don't feel the weight of it, I think, is probably a problem. So I guess I'll embrace the trauma, but try not to be affected by it. How's that?
Thanks. Were there any further questions?
Sure. So there's been recent laws enacted as of January 2022 that have forced the judiciary to look at trauma in terms of sentencing and giving great weight to trauma and victimization of the defendant. So despite the recent legislation, it seems like there are some judges that are still reluctant, depending on where you go in the county, to actually follow these guidelines. What can the defense do to help the judges along in terms of this, other than making a complete record, of course, and trusting the appeal process? But
Well, you're in Pomona, right? Well, that's one of the issues. When I was a prosecutor, I briefed everything. So, and I don't know if that's just such a simplistic answer than to educate, because even though you're familiar with new legislation, not every judge is, and not thoroughly. We do have trainings on new legislation, but they're great, but they're quick because we're learning so much. And so I think briefing the issue, bringing it to the judge's attention, bringing it to the prosecutor's attention, I think those are really the only things you could do at this at that stage. Maybe my colleagues have other
I
suggestions.
think it's actually consistent with the whole theme since the first panel. It's humanization, right? You humanize your clients, oh man. So that concept where you present the judge with the law and the person, right? So that maybe that wrote kind of, present, discharge this sentence. If no, judge, you need to look at the law, and this is the human. See my client, right? See the victim, see my client, the person. I think that's probably the best.
Is there anyone else who would? Awesome.
No further questions.
Let's give her a hand.
Submitted.
Would you like to move?
Would you want to say a final thought
Yeah, sure. Well, thank you everyone for being here. I really appreciate your presence in this space. Final thought that I had in terms of what we just talked about, or what you were just mentioning, was that a lot of this is, I think we've heard the word encouraging a lot, but that folks can, I'm not exactly sure like what context in which this happens or how what strategy is used to help people see the entirety of someone's being, circumstances, and experiences, and how that can be brought forth for consideration and kind of allow us all to understand how we got here, what happened that we are in this space and at this juncture and in this predicament. But hearing that really helps, because I think that it will, in terms of what we're talking about today, reforms and how to make things more human and how to make processes more understanding of that humanity. I can't say anything else but uplifting, right? To hear that all that is in consideration and will hopefully continue to just get more refined as we all walk through this process together. So that's what came to mind, and yeah, I really appreciate everyone's presence, and I don't know if we mentioned this before, but it's in terms of judges and what they're allowed to do. I think Florida spoke to this, where just having this collaboration here with one another is really special to me, because it helps all of us kind of learn a little bit, or just kind of understand a little bit more what each person is kind of there to do, and how all the parts work together, and how, or if the parts work together, what we can do, and what solutions we can bring forth. So yeah, I appreciate this collaboration so much, and everyone who's attended.
Thank you.
Thank you, Stephanie. Big
Yeah, and
thanks.
just in closing, I wanted to thank, again, everyone for being here, but also to really highlight that I feel like we began our discussion and dialogue with the weight of survivor voices. And honestly, I just want to thank all the panelists for making, I believe, the survivors in this room feel heard. And the collaboration this does just highlighted that I really felt throughout the conference today and the dialogue. And now that I'm a law professor, I also have an assignment for everyone. I hope, right, that you will take the spirit of this conversation that we had back to your workplaces and be willing to engage in difficult conversations about improvements, or as some of us believe, changes that have to be made in our criminal system, and that we will continue to have those hard discussions. And so for the law students in the room, please have those discussions with your peers, right? Because you are the folks that will perpetuate the system that we have. And for those of you on the panels, you've all reached the survivor leaders as well as our allied professionals, peaks in your career where you hold a lot of power. And I hope that you'll use that power, hearing from survivors